Amongst the various important roles that they play in our society, the courts are the guardians of Canadians' constitutional liberties. So right away, they're going to play a very important role in providing accountability and justice for what occurred during the G20. There are two types of cases that are currently before the courts involving the G20. The first is criminal court cases, the second is civil court cases. Criminal court cases, as it might sound, involve criminal charges. They're brought by the state against the individual, and the ultimate goal or possibility there is imprisonment. Civil court cases are the reverse. They're brought by the individual, often against the state, and the goal is to get financial compensation for what occurred during the G20. "1,100 people were arrested in Toronto during the G20. It's the largest mass arrest in the history of this country. Of those, only about 278 were actually charged with an offense, meaning more than 800 people were released without any charge of any kind. This raises a serious concern that perhaps the arrest powers of police are being used in an abusive and potentially unconstitutional manner. Of the 278 who were arrested, that number eventually rose to 304 as a result of arrests that took place after the G20 summit. Now the police decided not to release about 263 people, and instead decided to hold them for what's called a bail hearing. Bail hearings occur where the state feel that you pose such a threat to the public or a flight risk that you cannot be allowed to be released prior to your trial. So of those 263 people, the court only actually denied bail to fewer than 10. So there's a secondary concern now that police process powers to release people are being misused, and that these might be used in an unconstitutional manner. The G20, or the CCLA, has some concerns about bail conditions that were imposed on people who were released and not held subsequent to their trial. The most important concern we have are prohibitions on what's called political organizing, political activity, or political participation, which were included in a lot of bail conditions. This means individuals cannot be involved in any way in any political activity, and some of these conditions were not even limited to Toronto, but they apply nationally. Now, of course, all Canadians have a democratic right to freedom of expression, to freedom of association, and these rights are severely curtailed by these kinds of restrictive bail conditions. And it's our position that, defined very broadly to preclude all political participation or all political action, they may be unconstitutional. Now, of the individuals who were released on bail and those who were denied bail, all had what's called a first appearance at the Ontario Court of Justice in Etobicoke this week on Monday. 304 people were scheduled to appear before the JP, the Justice of the Peace, to hear what's happening with their charges. Now, in the time it's taken between the conclusion of the bail hearings and this first appearance, the Crown has had the opportunity to review some of the police files, and the Crown actually withdrew charges in 58 cases on the basis that there was no reasonable prospect for conviction or there was no public interest in pursuing the prosecution. So there is another concern that perhaps police powers were being used in an abusive manner during the G20 to arrest individuals where no crime had been committed. Carrying on, the individuals who appeared at their first appearances will now have subsequent court appearances that have been scheduled in September and October. Throughout those processes and leading up to the trial, there will be charter motions for alleged charter violations of rights and liberties and applications to exclude evidence or to end prosecutions because of police misconduct, and the CCLA intends to follow these very closely and, where appropriate, to intervene in the cases. The other type of court action that's taking place right now are civil actions, and as I said before, civil actions are where an individual is suing another person, or in this case, usually the police or the government, for personal or private wrong, and they want financial compensation as a result. The most important vehicle for civil actions relating to the G20 that are occurring right now are class actions. Now, a class action is a special type of lawsuit. It occurs where a lot of individuals have the exact same claim against a single person or organization. It's far more efficient in these circumstances to allow one person, who's called a representative plaintiff, to bring the claim him or herself before the court and to argue the case. If that person wins, everyone in the class wins. Currently, there is one class action that's been filed already in Superior Court relating to the G20. That class action is brought by two lawyers, Eric Gillespie and Mark Klippenstein, and that refers to every individual who was arrested or detained during the G20 and not charged with an offense. So that number might already number around 800 to 850 people who were arrested during the G20 and simply released without any charge put against them. The pleading was put before the Superior Court about 3 weeks ago, and in the action, for about 800 people, they're asking collectively for about $45 million. The defendants listed are the Toronto Police Services Board, which is legally responsible for the conduct of the Toronto Police, and the Attorney General of Canada, who is legally responsible for the conduct of the Royal Canadian Mounted Police. There are substantiated reports that a second class action will be launched this week by another attorney here in Toronto that will focus on a different group. That class action will include individuals who were charged and arrested with an offence in Toronto, so that includes about another 304 individuals who actually were charged with an offence and either taken into custody or released on a promise to appear before a court. It will also include the property owners here in Toronto who suffered damage or loss of revenue as a result of the G20. The federal government has a limited compensation fund for businesses that were directly affected by the G20, which their definition largely includes businesses that were inside the security fence. Of course, businesses outside the security fence bore the brunt of the vandalism that occurred on Saturday and Sunday of the G20 summit, and due to the large shutdown of the city, businesses across the city suffered large financial declines. So they'll be the focus of the second class action. Of course, individuals do not have to resort to a class action to bring a claim against a state. The normal process is for individuals on their own to sue the police, and there are two mechanisms to do that. One is small claims court. Small claims court deals with claims for less than $25,000. The procedures are simple and it is designed for someone to approach and apply without a lawyer. Small claims court allows you 2 years after the incident to bring a claim, so right now we are not aware of any claims that have been brought already, but of course it's very early on in the period. The other process is a claim before the Superior Court. Superior Court handles claims for financial compensation of more than $25,000, or where you're asking for something other than money. For some people, it's very important to have a declaration by the court that their rights were violated during the G20, and only a Superior Court can provide you with that particular remedy. Like a small claims court, an individual has 2 years to bring a claim before a Superior Court after the incident they are complaining about.